Every Sunday, we bring in live immigration updates, and we do take live questions. Today, our guest is Rebecca Chen from renewal PC. Rebecca, we are here to discuss about the H4 delays, as we know that the 485 data has come out, where it's going to be almost until 2032. The prior dates are not going to touch January of 2015. That's where until which time the people have filed the 482 application. The inventory for Indians is that long that it's going to take 2032 for the priority date of January 1st to become current. Now, all of the people are relying on the H4 EAD, Rebecca. Now, what are the things that they need to make sure? Because if there isn't a gap of the EAD, though, if there is no employment authorization for a particular period of time, they will lose the job. Most of the jobs are not like that where they can take off whenever they want to, join whenever they want to. The companies are not willing to. At the same time, the job duties may not allow people to just hop off and hop on. So what are the steps that they need to do to make sure that their H4 EAD is continuously without any interruption of the employment, Rebecca?
Yeah, so the main thing to do is to make sure you are filing the EAD renewal as early as you can, and to be strategic in the way you file the H4 EAD renewal. The ideal situation is if the H4 and EAD applications can be filed concurrently with the H-1B application. If the H-1B is due for an extension and the H-4 and EAD can be filed along with it, that's the best scenario, because right now the government's policy is that the H-1B, if it is filed in premium processing, the H-4 and EAD will be approved at the same time, in about 3 weeks. And we are observing that that is the case, that the government is issuing the EAD shortly after the H-1B is approved if all 3 applications are filed together. If for some reason all 3 applications can't be filed concurrently, and we know there are some companies out there that for whatever reason their policy is not to file the H-4 and EAD concurrently, or maybe sometimes there are other reasons, like the I-140 doesn't get approved until after the H-1B was recently extended. There is a way for the H-4 EAD holder, if they have an existing EAD, to get an auto extension. There is sometimes a misconception that there is an automatic extension for H-4 EADs the way there is with the GC EADs. It's not automatic, the extension of an EAD, if it's based on an H-4. It can only be applied if the H-4 status is valid for longer than the current EAD. And so the way that you can do that if premium processing isn't an option is to travel. There is automatic revalidation, which is an option where anyone can travel to Canada or Mexico for a period of 30 days or less. And if they're coming straight back, they don't need even a valid visa in their passport. If they have an expired visa and an H-4 approval notice that has an I-94, then they can come in. Another way is if the H-1B extension has been approved, then they come back with the H-1B extended approval notice. So we have noticed that even though it's not an official policy, if the H-4 holder and the H-1B holder are coming back as a couple, for the most part, CBP will grant both people the H-1B holders end date. So that can be a way for the H-4 to get an extended I-94 quicker than it will take for an I-539 to be approved. Because the I-539, if it's filed on its own, it can take 5 to 6 months, sometimes even longer. So travel with the H-1B visa holder with the extended H-1B approval notice can be a way to extend the H-4 I-94 quicker and to therefore get the auto extension.
Okay, so Rebecca, what you short formly pointed out is that filing H-1B and H-4 EAD together is definitely the best option, and filing earlier, as we know that H-1B can only be filed 6 months before it expires. That's probably one at the period of 6 months period, not wait until last month and file the H1 and H4 EAD and probably file in a premium processing H1B. And they don't have to pay the extra premium processing for the H4 or EAD. That's
Right.
the best option. And the alternative options are only in the case where they don't file H1B and H4 and EAD together, the alternative options that you discussed. And thanks for pointing out that that 540-day rule is not automatic for the H4 people, but it's automatic for the GC EAD extension, but not for the H4 EAD. So please observe the tips of what Rebecca has given to avoid any employment gaps. We're going to take live questions, guys. If you have any, you can always call our show at 833-882-8872, and we're going to take live questions. Let's get to the first person. 7155, you have a question for us. 7155, last 4 digits, 7155. Uh-oh, he unmuted. Can you unmute yourself? 7155. Rebecca, why? Yeah, go ahead, 71. Go ahead, sir.
Yeah, hey Rahul. Thanks for taking the call, Rahul. My question is regarding the visa stamping. It's been over 5 years since I went to India, and I'm not eligible for Dropbox because because of the 48-month rule, right?
Yeah.
But then in 2022, I went to Mexico for the H4 EAD, and as per your advice, we went there. So what I wanted to ask is, will that travel to Mexico override the 48-month rule, or do I still have to go for the interview only?
You did not get the stamping in Mexico, is that right? You just
No, I did not get this. I just used the AVR in Mexico.
Automatic revalidation.
Correct.
Rebecca?
Yeah.
Rebecca,
yes.
if 48 months have expired, he traveled to Mexico and come back, is he eligible for the Dropbox?
I don't think so. So the consulate wouldn't consider returning on automatic revalidation as kind of the issuance of a visa within 48 months. They still consider it an actual visa stamp in the passport within 48 months. So it sounds like you would not be eligible for the Dropbox, unfortunately.
Rebecca, explain how people can enter back, go to Mexico and come back, even though their visa stamping is expired. Of course, his I-797, I-94 is still valid. Can you explain what is that automatic revalidation? Is that valid only for Mexico, or is it people can go to India and come back without stamping?
It's only Mexico and Canada and some islands nearby, like in the Bahamas, Jamaica, sort of some of those islands nearby, although primarily it applies to travel to Canada or Mexico, and so it's for a direct trip from the US to Mexico and back without visiting any other countries in between, or directly to Canada and back without visiting any third countries in between. Also, one of the requirements is that you cannot have applied for a visa in Canada or Mexico in order to use automatic revalidation when you're coming back. And actually, CBP considers applying for a visa anything as even filling out the DS-160 and submitting it. Even if you don't attend the visa interview at the consulate, CBP considers submitting a DS-160 for a consulate in Mexico or Canada as applying for a visa in that country. So make sure you're not even submitting a DS-160 to the consulate in Canada or Mexico. But if you haven't done that and your trip is less than 30 days, then yeah, you can come back with a visa that is from 10 years ago. There isn't a limit technically on how old the passport visa can be, as long as you're coming back with a valid I-94, an I-797 approval notice with an unexpired I-94.
We'll go to the next caller. 2558, you have a question for us. 2588.
Yes, currently can you hear me?
Yes, we can. Go ahead, sir.
Yeah, I'm currently on H1B, and I have pending 485 also. So what happens in case of job loss or company closes?
I think so. This question is coming from Karim. Rebecca, as everybody knows that in the H1B, if you have a job loss, you have up to 60 days to get another job. You can be unemployed for 60 days. Now, of course, Karim is on H-1B, valid H-1B, and it's also an adjustment of status. And he would like to definitely keep the adjustment of status. Now, Karim, would you be willing to give up the H-1B? Because sometimes what happens is that to keep the H-1B, to keep the adjustment of status, you may have to give up the H-1B.
Mm-hmm. So, what are the options available if I leave the H-1B?
Rebecca, if he is willing to sacrifice the H-1B, okay? And is the 60-day rule applicable for 485 EAD also, or what are the options that he has?
So technically there isn't a 60-day grace period that applies to the I-485. So that's kind of another misconception out there. It's that the 60-day grace period is there. There isn't. Technically, there is no grace period for having a job offer for purposes of keeping the I-485 alive and valid. So technically, the rule is that from the time the I-485 application is filed until you get the final green card, you are always continuously during that time supposed to have a valid job offer. So that's an important distinction. It's a valid job offer, not necessarily active employment during that whole time. So if you do have a job offer that is lined up, even though you are not actively working for a certain amount of time, your I-485 can remain valid. In Kareem's case, where it sounds like he's concerned about job loss while the I-485 is pending, it does also matter a lot whether the I-485 has been pending more than 180 days. If it has been more than 180 days,
he has an EAD, it's more than pending for 180 days.
Yeah. If it's more than 180 days and you have the EAD, that is good news because the best scenario is, of course, if you can move to another employer without really a gap in between from your current employer, then all you need to do is make sure that the new employment is in a same or similar occupation to the one listed in your I-140. And the government has been pretty broad in interpreting same or similar. So as long as it's in the same industry, the same occupation generally will be fine. Even if you can't find a new employer, the EAD is very flexible. So again, if you are willing to kind of give up the H-1B, the EAD allows for self-employment. It allows you to start your own company. So a lot of people have actually, started their own business and self-employed themselves. And that counts as a valid job offer for purposes of keeping the I-485 pending. You wouldn't be able to stay on H-1B in that situation, of course, because the H-1B doesn't allow for self-petitioning or owning the petitioning company. But yeah, on the EAD, you are able to do all those things. And so that's one of the benefits of the EAD while you're on adjustment of status.
Can his wife employ him?
Yes. Yeah, we've had people do that too, because obviously if your wife applied for the I-485 along with you and she has the EAD, she can start her own business and employ you. You do need to make sure it is still a full-time job in the same or similar occupation. Those are still requirements. And especially if the job offer is coming from a spouse's company or the employment is from a spouse's company, make sure there's still all the proper paperwork involved, you're on the payroll of the company, all those things. But yeah, as long as all those are taken care of, that is fine.
We'll go to the caller. 6835, you have a question for us.
Yes, hello, can you hear me?
Yes, go ahead.
Yeah. Thank you for taking my call. My question is regarding the advance parole. Myself and my wife, we have advance parole, but my son, he doesn't have. Even though we applied all together, my son, he's like 13 years old, but he did not get yet. We tried to expedite, even we reached out congressman, but no results yet. My family is planning to travel this end of month, and I'm planning to travel sometime in June. So can he travel now? If in case he gets his advance parole, when I go, I can take that advance parole with me? Or
No,
will his advance parole be revoked?
he needs to have an advance parole before he travels, not after he travels, though. The best option that if you want to, is litigation. Going to the court is one option that you have. Is that and even if you go to the court, though, it takes approximately 65 days for you to get a result. So if you're having an option of going in the month of June, the court litigation also may not help. Rebecca, how, they're taking long time right now, like 17 months to do the advanced parole. Previously, they used to approve along with the EAD. Why is that USC has changed the policy of not approving the advanced parole at the same time?
We don't know. We don't see why this is more efficient than just issuing them as a combo card like they used to always do. But for whatever reason, a couple years ago, USCIS started what they called unbundling the I-765 and I-131. It may have been that they were under a lot of pressure to issue the EADs faster. And so it sounded like around the time that we saw the unbundling, it did look like the EADs were being processed faster. A lot of times people would get it within 3 to 4 months of filing the I-485, but the advanced parole would still take, well over 6 months, even a year or more in some cases. So we don't really know why USCIS decided to do that, or that is still a big problem. And so far, if there is time for litigation, which again, there may not be even time for litigation in this case, but that has been the most effective route that we've seen. So I believe, Stephen Brown in our office is the main attorney handling litigation. I believe his kind of rule of thumb is that if the advance parole has been pending for about 6 months, then he can file a delay lawsuit from there. So if you or anyone else out there has had an advance parole pending 6 months and you know that there's going to be kind of urgent travel coming up and just want to make sure it gets issued, we would recommend reaching out to Stephen.
We'll go to the caller, 3672. You have any question for us?
Hey,
3672.
this is Praveen.
Yes, Praveen?
Yeah. I am on my H-1B visa, which is valid up to 2026, and my I-140 is also approved. I entered this country in 2016, and from that time, I didn't move out. I didn't travel out of the country. So this Friday, my wife went for H4 interview with my kids, 10 and 9-year-old, at Hyderabad consulate. And the visa officer, when she submitted the document, the visa officer asked my approved or stamped visa. So she submitted my latest I-797, which is valid until like 2026, and I-94 is also valid until 2026. But he said that, no, we want the stamped visa, latest stamped visa of your husband, and they gave a pink slip to me.
Rebecca, is it required in this case where the person is on H-1B staying, working in the United States with a pay stub here in the United States? Is it required to have a stamping for his wife and child to get it? And if it is not required, what is a better approach for him to do right now?
It is not required. So we don't know why the consulate is asking for that in order for the H4 visas to be stamped. If they
maybe the company's lawyer should send an email to the consulate, then explaining it to them. Is that a good option, Rebecca?
They can try.
Yeah. Send an email. That should normally work, though, to the consular officer. Hey, sign a G28, send it attached, and send it to them. Hey, this is the lawyer writing. No, it's absolutely not required for this person to get the stamping to get the H4. That's the Ready Newman PC has been doing that for a couple of times and have been very successful in it, though. We see some young officers coming into the consulate. They don't understand the concept of the H-1B stamping. They think very similar to some other visas that are not completely related to H-1B. And they implement that policy into the H-1B, saying that the H-1B person must have a stamping. Hey, he has an I-94. It's valid. He has a paycheck. He's already in USA working in the United States. Those are important, though. Having an I-94 working and getting the paycheck, do you need to have stamping for your wife to get the visa? Absolutely not required. Rebecca, question is coming from different sources as our network is growing broader. What are the options for the people who are on student, who are 20 years old? These are children who are entering into United States, and they might have entered when they're 12, 15, whatever time. Now they are turning 20. Is there any other option for these kids to stay in United States after they turn 21 other than F1 visa?
Other than the F1 visa,
Right.
not many. If their country of birth is India, unfortunately, there aren't many other options unless they marry a U.S. citizen. Yeah, typically we see H4 children who are, not able to get the green card before turning 21. The main route seems to be changing to F1 status before you turn 21. And the main way to do that is applying for the I-539 with USCIS in the U.S. We recommend that over going to the consulate to apply for an F1 visa, because at the consulate they are more likely to evaluate for your ties to your home country, your temporary intention to leave the U.S. after finishing your studies, which for H4 children who have grown up in the U.S., you don't have much documentation of ties to India, most likely. So filing the I-539 in the U.S., we haven't seen any issues with that. And another benefit is that there is, since last year, premium processing is available for I-539 applications if you are applying for a change of status to F1. So you can get it processed much quicker than it used to take for an H4 to F1.
Yeah, the most practical option definitely will be F1. Now, there are options of J1 visas. There are options of Q1, P1, I don't know, whatever. But it's very specific. Very less number of people will be eligible for those things. I would say less than 2% or 3% of the people will be eligible for all the other options that are there. But definitely F1 stands on the top. J1 could be next in list at the most, but not many people will qualify for it though. We'll go to the next caller. Which is 5572. 5572.
Hello.
Phone number. Yes, go ahead, sir.
Hi, good evening. Actually, I am working for an IT company on L1B with employer A. Last year, employer B, he submitted a change of status, and I got selected in the lottery, and the change of status approved in
December.
So, but my employer B, December 2023. After RFP, it was approved in December 2023. But the problem is, employer B, he didn't start the employment, and I'm still continuing with employer A on L1A, L1B. So is there any legal issues if I continue with employer A on L1B?
Rebecca, his H1B change of status is approved in December. So technically, I would say that he is considered to be violating the status. Can he use the automatic revalidation by going to Mexico and coming back on L1? In this way, he doesn't have to go through the stamping issues. He can keep the H1B alive. Whenever he wants to convert to H1B, he can convert to H1B. Or will that be a problem?
That should be okay. If your intention is to continue in L1 status with employer A, then yeah, that will be the quickest way to kind of fix your status issue right now, is to exit the country and come back in with the L1B approval notice. So if you have the L1B approval notice with the I-94, like we said earlier, you don't need to even go for visa stamping if you're going to Canada or Mexico. So you could just go for a weekend and come back with the L1B approval notice, and that will put you back in L1B status.
But one thing I would say that this gentleman is not doing a good job, because his H1B was approved in December of 2023. Now we are in May of 2024. For 6 months, you are not coming to our show. You're not following our thing. So please continue coming to our shows here on Sunday. evening so that you can get knowledge about these things. Don't neglect these things. These are very important because right now we consider that you are not maintaining the status. To get back into status, what we call it as a Margaret switch is what you're supposed to do. 4795. 4795.
Hi, sir. Hi, Nitya Garu. Hi, Rahul Garu. Thanks for taking up my call. So I have a question regarding this. So for the H4 EAD validation, like you said that even it got expired until we renew, while it's pending, we have 540 days or so. So for this, is there any condition that should be met? Like, should we have a valid I-94?
Yes.
Yes.
Rebecca will explain the things. Rebecca, explain. I have a H4, which is expiring in June of 2024. H4 plus EAD, both are expiring in June of 2024. I filed my H4 plus EAD extension in April of 2024. I have a receipt notice right now. Can I continue working after June, or what are the conditions that are there for the 540-day EAD extension?
So as of now, in that scenario, the auto extension will not go into effect. The only way that you can activate the 540-day auto extension is by getting the H4 I-94 extended beyond June. And the fastest way to do that is by departing the US and going to Mexico or Canada. If you have the valid H4 visa stamp, that's the best scenario. In that case, you can go to Canada or Mexico and come back with the H-1B extended approval notice, and you will be guaranteed to get the extended I-94 at the border. If you don't have the unexpired H-4 visa stamp, you can still try going to Canada or Mexico, coming back with automatic revalidation. But in that situation, it's best if the H-1B visa holder travels with you, because they're not required to give you the longer end date, because your I-94 right now only says June 2024. But if you're traveling with the H-1B spouse who has a 2027 approval notice, for example, they're likely to just issue both your I-94s with that 2027 end date. And then from the time you come in, then after your current EAD expires, you are authorized to continue working for up to 540 days with the expired EAD, the I-765 receipt notice for the pending renewal, and your online I-94 that is now valid till 2027.
Rebecca, can we do this automatic revalidation? Let's say, for example, my I-94 is expiring in June of 2024. And based on what you're telling is that I can do this automatic revalidation extension until June of 2024, until my I-94 expires. What if in July I want to do that? Can I do that?
You should not. If you do not have a valid H-4 visa in your passport, don't try it after July, because you're not guaranteed to even be admitted back into the US. Because again, the baseline rule for automatic revalidation is that they will let you back in with an expired visa if you personally have an I-94 in your name that is still valid. So if you're coming back in July and you don't have an I-94 in your own name that is still valid, they may not even let you back into the US. It's still tryable. You can still try it before June, because you're guaranteed to be let in, and what you're hoping for is not only will they let you in, but they'll also give you the longer H-1B spouse's end date at the same time.
We have a question that came online where questions are asking, is prevailing wage determination required for every time we file the H-1B? We call it's online wages. It's just you go online and we just punch in a couple of things and it gets automatically there. It takes only about less than 1 minute for a legal assistant of ours to get that work done. So how do we know which prevailing wage has been used? You can always look into the LCA, and we will have to write it down what wage has been described. So it's a very easy way of getting the things done. 8573, you have any question for us? Oh, sorry. 8573, any question for us? 8573, you have any question for us? No, we'll go to the next one. 2779, you have any question for us? Phone number ending 2779. Yes, go ahead, sir.
Hey, Rahul. I've got a quick question for you.
Go ahead.
Yep. My story is like my priority date is like EB2, EB3, 2013. I work as a technical leader in one of the Fortune 500 companies. Sorry. Besides that, I'm actually supporting U.S. government for a distinguished project, basically. On top of that, I've been consistently making more than $500,000 last 4 years. So, knowing the visa bulletin movement and everything, do you suggest like
trying EB1A? Trying EB1A?
Yeah, that's right.
Absolutely, you should.
Good.
I mean, what's the lots you are going to get it? Just in case if you're EB, based on what you're telling though, you definitely are falling into one criteria, higher income limit, which is a requirement out of the 10 requirements, one of the requirement, critical role. And there are other requirement, critical role also you're falling into, but the third one also you need to try to fit into it. You should try. I mean, if you lose, what are you going to lose? Of course, the money that you pay to the lawyer is not going to come back, but it's definitely worth. Nowadays, things are much smoother. The percentage of approvals in EB1 has been very good right now. So you should try. If you fail, you will stay where you are at.
I don't have any publications as such, but
it's not
I know
publications is one of the 10 requirements, though. You have to only meet 3 requirements. That is one of the 10 requirements. You should at least get yourself evaluated with an immigration lawyer to see what are the things that you may be eligible for. I can clearly say that critical role, probably you definitely fits into. The second is high income. That's also you fit into it. Third one, you can always discuss privately with the lawyer to see which one you fit into, okay? But you should try.
Also, I'm another thing, Rahul. Also, I'm hearing stories that, qualifying for 3 criteria isn't going to be good enough. You will have to probably meet like more than 6 criteria, at least for them to consider your case to be valid. So do you...
no, not
how
true.
Do you,
not true. The law clearly says you should only qualify for 3. Yes, lawyers would like to try you to qualify for 6? Yes, that's what we try to do it. But you definitely don't have to qualify for all 6. Only 3 are required out of the 10 requirements for you to get the EB1A. Okay?
Currently, with my priority dates, I am looking at like at least 2 to 3 years from now to getting my case adjudicated.
Keep going. Keep going.
So my question is like, I'm actually looking for proper guidance. Can we set up some time and get my case evaluated if that is okay?
Sure. You definitely you can reach out. Okay. Okay. I'll go to the next person who is 3735. Can you unmute, please? 3735. Phone number ending with 3735.
Hi, Rahul. Thanks for taking my call. So I just had a question regarding the visa stamping. So due to the 48-month rule, I'm not getting any in-person appointment in India. I just wanted to check, in that case, can I go to Mexico for visa stamping? Will there be any complications in that?
Rebecca?
No, technically you can apply for a visa anywhere, at any consulate in the world where you can get an appointment. So all consulates right now are supposed to be accepting third country national applications. In practice, I would say we haven't heard of too many non-Mexican applicants getting appointments in consulates in Mexico. So You can apply at any consulate in any country. The issue then becomes securing an appointment in that country that's, earlier than what you can get in your home country. And we see this more with Canada. I'm not as sure about Mexico, but for example, Canada is still, technically they accept third country national applications, but they seem to not make them that available. And so in practice, the earliest appointment that you can get at a consulate in Canada is still quite far off. But you can still check. You can still definitely apply and check appointment availability at those consulates.
So Rebecca, she can get the appointment anywhere right now based on the State Department new rules, is that right?
Yes. Mm-hmm.
Okay. We'll go to the next caller, 2558. You have a question for us.
Yeah, hello.
Yes, go ahead,
Can
sir.
you hear me?
Yes, we can.
Yeah, I wanted to know, I'm on H-1B and wanted to know the wage determination happens with every extension, or it is only the first time?
It has to happen every time, okay? Because every year the wage determination changes. But it doesn't take much time. It just takes 1 minute. We just go online, OES wage survey, you just punch in a couple of things and we get the wage survey. This is different than the form labor certification, okay?
So how can we know that are we being paid as per the approved wage?
You can look into the LCA. It will tell you what wage they have used into it. You can go online and check if that wage is correct or not. Rebecca, can you explain what's the prevailing wage difference between why it takes 8 months for you to get a prevailing wage for the POM labor, while it takes 8 seconds for you to get, or maybe I'm exaggerating on the 8 seconds, maybe 1 minute for you to get the prevailing wage for the H1? What's the difference between that, Rebecca?
Yeah, definitely for the PERM process, it's the same set of data that the DOL uses to come to the determination of what the prevailing wage should be. But for purposes of the PERM process, you submit a much more detailed description of the position that the company is sponsoring you for, the job duties, the title, the work location, whether you're supervising anyone, whether you have to travel, whether there are multiple work sites, that kind of thing. There are all these details about the job that we're required to submit to DOL, and it gets reviewed by an actual officer. And then that officer, based on the job description, decides what SOC code the position falls into, what level 1 through 4 it falls into, and then they determine based on that what the prevailing wage is. So it requires an actual person to review it and make a determination. And so that ends up taking, the current processing time is about 5 months, 5 to 6 months, I believe, for prevailing wage determinations for PERM. For the H-1B, we don't need an actual person to review the job and make that determination. We just submit the LCA. We kind of determine what the SOC code is, select the wage level based on, the position, the duties, and the salary being offered, and we submit that LCA to DOL. They don't get a job description as part of our LCA submission. They are just reviewing it to see if we selected the wage level correctly, the prevailing wage correctly according to the geographic location and the SOC code. So it's a much quicker determination for the LCA because mainly it's self-selected. And then, of course, USCIS, when they review the H-1B application, they can always question whether the SOC code that was selected was appropriate or not, but it's not DOL's job at the H-1B stage. So that's why it's much quicker for H-1B purposes.
Sure. We'll go to the next caller, who's 3050. You have a question for us.
Hello, good evening, sir.
Good evening.
Hi. I'm a student on H-4 visa, and I have some student-related questions. Can I pose those questions here?
Sure, please.
So I'm actually 20 years old now, and then by March of 2025, I'll be 21, and I think I'll be maxed out as an H-4 visa holder. So I was just thinking, is the only option in front of me is to do a visa status change to F1, or since my parents have I-140 approved, does that mean like there's some things like I can stay on their visa since it's like they're in the process of getting a green card?
No. Since the priority date is not current, which I'm assuming it's not current, and you didn't file the 485 and got an EAD, no. Based on the I-140 approval of your parents, you cannot stay in the country on any other visa or any EAD option at this point of time. There is no option, none whatsoever at all. I know, unfortunately, it's a very saddening thing. Had your parents sneaked into the country illegally by jumping the wall and coming into United States, you would have gotten EAD under the DACA rule. But since your parents followed the law legally, came on H-1B or F-1 and converted to H-1B and maintained, paid taxes and got the I-140 and stayed legally, you are getting punished. I'm sorry to say that, but that's how the things are right now. Rebecca, you have a different version?
Okay. No,
Yeah.
it's good. So, I just have another question.
Go ahead, ma'am.
What do you have an idea, like a rough estimate of what's the waiting time? So if I were to like do the process for converting to F1 visa, will it take like 6 months, 8 months, or how long?
It's taking approximately 6 months right now to get the F1 approved. However, as Rebecca has pointed out, you have a premium processing, which will take about 3 to 5 weeks for you to get an F1 approved. One thing to be noted is that when are you graduating? You told me that you're becoming 21 in March of 2025. When are you graduating though?
I'm actually, I take more courses, so I graduate in fall 24. So I still want to continue my master's here, so like that's why I have to move to F1.
You are going to graduate in 2024, May. Is that what you said? I mean, we are already in 2024.
Fall, like this,
I'm sorry?
December 20.
Okay.
December 24.
But then if you're going to graduate and then you're going to go for the master students though, then you lose the work permit of OPT for 1 year. And then is a degree a STEM degree?
Yes, it's a CS degree.
If it's a STEM degree, then you're losing a 3-year work permit unnecessarily though. You may want to have your parents discuss, because if you just graduate on H4 and try to graduate early on H4, and then you try to move on F1 to the master's level though, you get only 3 years of work permit, which is after you graduate in the master's, you get 1 year of OPT plus 2 years of the STEM extension. But if you right now get into student visa though, when you graduate, and you need to get the student visa approved way before your graduation to be eligible for OPT. So if you're graduating in December, I would rather want you to file the F1 right now in premium processing.
Sure. So there's premium processing for F1?
Yes, there is. That's what Rebecca said. Yeah, that is. Okay, so Hema, I want you to do one. Yeah, I want you to do one thing. Get an I-20. Starting from August, of course, you get an I-20 from your university. You file the F1 visa in premium processing right now. Don't wait and get the approval. The reason is that if you wait until you go to master's, you lose a 3-year work permit, which you needed. Okay?
Yes, sir.
Okay, wish you best of luck, Hema. We'll go to the next caller, 4795. 4795. Hi, hello.
Hi, sir. Are you able to hear me?
Yes.
Thank you for taking up my call. I have 2 questions. Recently my H1, my H4 got expired, and before 2 months before that, we have applied for the extension along with my husband's H1 as well as my H4 and H4 EAD. So my question was, so we waited 2 months and it didn't get approved by then, and then I have to quit my job, or I have to take a a break from my job. So now we have applied for the premium processing. So my question is, along with H1 premium processing, would I get approval for my H4 EAD as well?
Did you said you filed H4 plus EAD together with the H1B or without?
Together, sir. H1, H4, H4 EAD, all three together.
Aha. Sounds good. Rebecca, so H1, H4 and H4 EAD was being filed in regular processing. Now they're converting. Will she get the H4 and EAD approval along with the husband's H1B?
Yes. Yeah, you will. The EAD card usually arrives within 1 to 2 weeks after the H1B approval.
The approval will happen at the same time, but your EAD card will be received within 2 weeks. So even though you're converting into premium processing, at this point of time, you still will get the H4 plus EAD at the same time. It will not be different though. It will be at the same time you'll get it. Rebecca, before we conclude, you have any other comments on the things on the H4 plus EAD particularly though? What mistakes people do?
Yeah, like in this case, if it sounds like if the H1B had been upgraded earlier, then the caller wouldn't have had to stop working potentially. It sounded like she needed to stop working because the EAD expired while everything was pending. So yeah, definitely filing all together, but also filing early and if possible, doing it in premium processing from the start if the company is allowing you to. The premium processing fee is the only part of the H-1B fees that can be paid directly by the employee. All other H-1B fees have to be handled legally by the company, but premium processing, because it's optional, can be paid for by the employees. So if your company, is reluctant to pay for it, you can offer to pay for it as long as they sign the I-907 request, if it will help, make them willing to do it.
Thank you very much for tuning to our show, guys. You can keep coming every Sunday at the evening time. You can come and have the live questions. We're here to answer any immigration questions that you have. Thank you very much. Thank you, Rebecca, for coming in.
Thank you.